Let's start at the beginning. For the first 100 years or so after the ratification of the Constitution, Congress enacted little legislation under its Commerce Clause authority. Some scholars claim that this is evidence that the original understanding of the term commerce was rather narrow, encompassing only trade. But Chief Justice John Marshall did not take so narrow a view. Gibbons v. Ogden stands for the idea that implicit in the authority to regulate interstate commerce is the plenary power to regulate commercial intercourse. Chief Justice Marshall's notion that anything that affects interstate commerce could fall within the scope of the commerce power isn't exactly surprising so soon after his opinion in McCulloch v. Maryland was handed down. In Gibbons v. Ogden, New York State had granted exclusive rights to navigate its territorial waterways by steamboat to two individual steamboat operators. The United States had issued coasting licenses to other steamboat operators under a 1793 federal law, and a licensee of the original New York rights holders sued in federal court to stop federal licensees from using New York's waterways. The Supreme Court held that Congress did have authority to regulate navigation under its power to regulate interstate commerce. The court construed commerce as including not just traffic, but also intercourse. Thus, the power to regulate commerce is the power to set rules for engaging in commercial intercourse. Chief Justice Marshall went on to say that commerce among the states may affect intrastate commerce, but does not include commerce which is completely internal, which is carried on between man and man in a state, or between different parts of the same state, and which does not extend to or affect other states. But as we'll see as this tutorial goes on, this turns out to be a much more complicated idea than it sounds.